Supreme Court of India allowed the appeal in matter of NAUSHEY and others versus State of UP and set aside the order of High Court in application under Section 482 CRPC and proceedings in complaint case pending in the Court of Additional Chief Judicial Magistrate, Moradabad. The appeal questioned the correctness of the order of High Court, holding that a case involving allegation of commission of offence under Section 307 of the Indian Penal Code cannot be compounded. Five of the eight appellants before the High Court, Naushe Ali, Khushbu Ali, Khurshid, Raza Ali, and Nanne, were before the court in appeal. The other three had passed away. The gravamen of the allegation was that the appellant's party wanted to pass the irrigation water through the field of the complainant by forcibly digging the land. When it was resisted by the complainant party, the appellant's party abused them in filthy language and assaulted Mahmood, son of Abdul Latif, with lathi and iron bars. When Mahmood ran to save his life, Abdul Waris opened fire from his rifle. According to the complainant, on hearing the sound, Munnan and Vilayat, son of Anayat, came and saved them. Thereafter, they reached the police station to lodge a report where they found that the appellant's party was already present at the police station. A complaint was lodged by Mahmood, but the thumb impression on his behalf was put by his father Abdul Alif. After investigation, the police filed a final report stating that the complaint was false. It was recorded that during the course of investigation, from statement of witnesses, it was found that the case had been falsely registered by the complainant as a counterblast to another FIR lodged by the appellant's party. However, on 5 September 1992, the police report was rejected by six additional Chief Judicial Magistrates who summoned the appellants and three others, Abdul Waris, Rashid, and Masita, all who are now deceased, for trial for offences punishable under sections 147, 148, 149, 307, 324, 325, and 323 of IPC and issued warrants. Aggrieved, the appellant challenged the order dated 5 September of trial court before the High Court in criminal revision, where an interim order was passed staying the order. The criminal revision was ultimately dismissed after it remained pending for nearly 23 years. It is the case of appellant's party that the dismissal of criminal revision was not known to all of them till 2022 when they received summons from the trial court. It appears that in meantime, due to intervention of the elderly persons of the village, a compromise was entered into between the injured and the appellants. Based on the compromise, an affidavit of the appellant and three others were filed uh, under Section 482 CRPC in a criminal miscellaneous application before High Court of Judicature at Allahabad, praying for quashment of the entire proceedings in view of compromise. It has also come on record that the case lodged on 11 August 1991 by appellant's party was settled during lifetime of Abdul Waris. There is no dispute that the said case is not pending. However, by the impugned order on the ground that the matter related to offence under 307, in which here are injuries and fracture of head of distal phalanx of left ring finger, the High Court held that the matter cannot be compounded. Supreme Court considered the question that whether the present case is a fit case where proceedings could be quashed, particularly when 307 IPC has inter alia be invoked in the summons. Supreme Court stated that we want to set right the errors that occur in the short order of High Court, as it has not appreciated the difference between compounding of an offence and quashment of proceedings. It referred to the case of Gyan Singh versus State of Punjab and others, quashing of where quashing of offence or criminal proceedings on ground of settlement between the offender and victim are not considered same as compounding of offence. Even though compounding and quashing are conceptually different, this court was careful in pointing out that merely because there is a settlement for certain categories of offences, proceedings will not be quashed. This is on the premise that crimes have a harmful effect on the public and consist of wrongdoing that seriously endangers and threatens the well being of society. Therefore, they cannot be quashed only because the accused and victim have amicably settled the matter. Will the mere mention of Section 307 IPC in the criminal proceeding force the court to adopt a hands off approach when parties come forward with a settlement? In that event, what should be the duty of the court? And what are the tests to be applied to decide in which cases settlements would be accepted and in which cases it would not be? In state of Madhya Pradesh versus Lakshmi Narayan and others, after discussing the ratio in Narendra Singh and others versus state of Punjab and another, Supreme Court held that Offences under 307 IPC and the Arms Act would fall in the category of heinous and serious offences and therefore are to be treated as crimes against the society and not as individual alone, and therefore the criminal proceedings for the offence under section 307 IPC or the Arms Act which have a serious impact on the society cannot be quashed on exercise of powers under section 482 of code on the ground that the parties have resolved their entire dispute among themselves. However, the High Court would not rest its decision merely because there is a mention of section 307 IPC in the FIR or the charges framed under this provision. It would be open to High Court to examine as to whether incorporation of 307 IPC is there for the sake of it, or the prosecution has collected sufficient evidence, which, if proved, would lead to framing the charge under Section 307 IPC. For this purpose, it would be open to the High Court to go by nature of the injury sustained, whether such injury is inflicted on the vital or delicate parts of the body, nature of the weapons used. However, such an exercise by High Court would be permissible only after the evidence is collected, after investigation and charge sheet is filed, and charges are framed or during the trial. Such exercise is not permissible when the matter is still under investigation. Therefore, the ultimate conclusion of the decision of the court in Narinder Singh should be harmoniously read as a whole and in the circumstances above. While exercising the powers under 482 to quash the criminal proceedings in respect of non-compoundable offences which are private in nature and do not have serious impact on the society, on the ground that there is a settlement or compromise between the victim and the offender, the High Court is required to consider the antecedents of the accused, the conduct of the accused, namely whether the accused was absconding and why he was absconding, how he managed with the complainant to enter into a compromise, etc. Court also referred to the case of Lakshmi Narayan, where it was held that it would be open for the court to examine as to whether incorporation of 307 is there for the sake of it or whether there is evidence to back it. It has been held that courts may go by the nature of injuries sustained as to whether they are inflicted on vital parts or the weapon used. Coming to the facts of this case, there is a settlement between the parties. The case by the appellant's party, which was prior in point of time and that too on the same day of occurrence, has been settled. It should be recalled that outside after the investigation, police actually closed the case in its final report. It was the trial court which refused to accept the same and summoned the appellants. The incident is about 33 and a half years back. No doubt there is a reference to the firing in the FIR, but admittedly there was no injury. The allegation is that firing was done by Abdul Waris and he has now been deceased. The facts, assuming to be true, also do not make out a case for common object of the appellants under 149 IPC insofar as 307 is concerned. The role attributed to 7 members, including 5 appellants, is not specific. General allegation was that they abused in filthy language and assaulted Mahmood with lathi and iron bar. The specific individual role was only attributed to Abdul Waris, who is now deceased. No recoveries were made of any pellets. The court was also inclined to conclude that considering the overall circumstances, the nature of the weapon, the nature of the injury, the offence alleged on facts does not fall in that category of cases where court should deny relief in the event of settlement. At the highest, the offence alleged could be one under 326 of IPC. It could not be said on facts, considering all circumstances, that this is a crime which has a harmful effect on public and thus it has the effect of seriously threatening the well-being of the society. Supreme Court made it clear that we are praying so on the facts of the present case. We are also firmly of opinion that proceeding with the trial when parties have amicably solved the dispute on present case would be futile and ends of justice require that settlement be given effect by quashing the proceedings. It's a grave abuse of process to let this trial remain pending under above circumstances, particularly when the dispute is settled and resolved.